Things are happening. Today, proceedings begin at the International Court of Justice regarding Israel's actions in Gaza. And there may be some of you who want to follow it, but you have no idea what the International Court of Justice is, or what is happening, or how to follow it, or what matters. Well, this is a quick explainer. I would like to first offer a disclaimer that I am, of course, not a lawyer. So don't take my word for it. Take these people's words for it. Incredible international lawyers that I follow on Twitter. You should follow them. They are the best source you will have for following the proceedings over the next few days. But here is a basic layperson explainer of the information you need to know in order to follow the proceedings over the next couple of days. What is the ICJ? Great question to start with. So in order to confuse us, they put two international courts in the same place. So the International Court of Justice and the International Criminal Court are both located in The Hague in the Netherlands. The International Court of Justice is the one that we are concerned with. Now, in contrast, the International Criminal Court works like a criminal court. There is a prosecutor who investigates and brings charges against individual people that they believe have violated international law. In contrast, the court that we're looking at, the International Court of Justice, works more like a civil court in that a party, or in this case a state, brings a case against another state and the court resolves the dispute. Now, something worth mentioning is that this court is fully consensual. What I mean by that is that a state has to consent to the court resolving the dispute in order for it to have jurisdiction. Now, there are two ways this can occur. Firstly, a case can be brought and both states can be like, yep, deal with it. And that makes sense because a lot of the issues that the court actually deals with relate to borders and maritime issues, not genocide. So that tends to be fine. People consent to having the court deal with it. Alternatively, if you have signed up to a treaty, that often involves something called a compromissory clause, not a lawyer, which means that by signing up to the treaty, you consent to the court dealing with any disputes related to that treaty. So the court has no jurisdiction to intervene whenever international humanitarian law is breached. It can only intervene when both parties consent or a treaty is involved to which both parties or both states have signed that treaty. So in the case of the Genocide Convention, Article 9 asserts that disputes between contracting parties related to interpretation or implementation or fulfillment will be resolved by the court. So in signing that convention, in signing on to that convention, you are consenting to disputes being resolved by the court. Now, a lot of the conversation around what is happening in Gaza relates to international humanitarian law, crimes against humanity, war crimes, etc. But the court has no jurisdiction on those things. It can only focus on the Genocide Convention and whether or not Israel has violated that convention or failed to uphold its obligations under the convention. That's all it can consider. Which leads me to the next question. What is the Genocide Convention? Genocide is understood as per the convention as follows. Article 2. In the present convention, genocide means any of the following acts committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group as such. A. Killing members of the group. B. Causing serious bodily or mental harm to members of a group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the group. E. Forcible transferring of children of the group to another group. A lot of people would be confused by the claim of genocide because they feel that as terrible and catastrophic as the situation in Gaza is, not enough people have been killed for it to be classified as a genocide. However, if you read the convention closely, numbers actually have very little to do with it. What matters is intent, the intent to destroy a group in part or in whole. The one place where the ICJ has found that the Genocide Convention was being violated was in Srebrenica, where it's generally accepted that between 7,000 and 8,000 Bosniak Muslims were killed. This is precedent that numbers are not what matters, intent is what matters. The intent to destroy a group in part or in whole. Now, of course, intent is also the most difficult thing to substantiate, especially in the context of war. Another thing I think is quite important is that when cases go before the court in relation to the Genocide Convention, more and more clarification of interpretation is given by the different parties to the convention. So some things that I found very enlightening in relation to the numbers thing specifically, I'm just going to put those interpretations up on the screen and read through them. The Genocide Convention does not require that in the determination of the specific intent to destroy, there should be a focus on the numbers of victims killed, nor has this factor been determinative in international criminal tribunals. Indeed, circumstances may be such that the perpetrator cannot, or decides not to, avail itself of the fastest or most direct means to accomplish the physical or biological destruction of a protected group. Another reason not to focus on the numbers of victims killed to determine specific intent is that the figures may be deceptive, as they most likely would not take into account the long-term deaths that may result in the destruction of a group, nor would they necessarily account for the biological destruction of the group. It is noteworthy that the scope of the Genocide Convention covers not only physical but also biological destruction of the targeted group. The court has already recognized that Article 2C of the Convention covers methods of physical destruction other than killing, whereby the perpetrator ultimately seeks the death of the members of the group. Examples of such conduct recognized by the ICTR include subjecting a group of people to a subsistence diet, systematic expulsion from homes, and the induction of essential medical services below minimum requirement. But why South Africa? Even if we were to grant that Israel is violating the Genocide Convention, what does that have to do with South Africa? Glad you asked. Within the Genocide Convention, there is a duty imposed on all those who have ratified it to prevent genocide. The International Court have asserted that the obligations of the Genocide Convention are erga omnes. Not a lawyer, don't know if that's correct. But it basically means that these obligations have to be upheld no matter what, because they are of great importance to the international community. Every state that signed on to the Genocide Convention has an inescapable responsibility to try and prevent genocide where they believe it is happening. South Africa simply has to establish that it believes that Israel is not living up to its obligations under the Genocide Convention. There is actually very recent precedent for a third-party state filing a petition in a case where it believes the Genocide Convention is being violated, and that is the 2019 case of the Gambia against Myanmar. None of the Gambia's nationals were affected. Gambia itself wasn't affected, but the court decided that it did have the right under the convention to file this petition in order to prevent genocide. And so it would be very odd for the court to say that it was okay for the Gambia to bring a petition against a state that it's not directly affected by, only to turn around and say that South Africa can't a few years later. It's very unlikely. Have there been any other cases relating to genocide in front of the ICJ? Only 3 cases have ever been brought to the ICJ in relation to the Genocide Convention. The first one, and the only one that has a final ruling, was Bosnia v. then Yugoslavia, now Serbia, in 1993. And I find that case very interesting because some parts of the petition were found to be in violation of the convention, while others were not. So it shows the flexibility that the court has in determining violations. In the past few years, 2 more cases have been put forward in relation to the Genocide Convention, and that's the Gambia versus Myanmar in 2019, which we've already mentioned, and Ukraine versus Russia in 2022. And both of these cases are seen as highly unorthodox. The Myanmar case was unorthodox because this is the first time that a third-party state had filed a petition in such a way. And the Ukraine v. Russia case was unorthodox because Ukraine wasn't suggesting that Russia was perpetrating genocidal acts against Ukraine. It was arguing that Russia had used the pretext of genocide to justify its invasion of Ukraine. And so it's actually bringing the case to the ICJ to demonstrate that Ukraine was not committing a genocide, and therefore Russia had no legitimate reason to invade Ukraine. So that's a very unorthodox and interesting application of the Genocide Convention. So will it be determined if Israel is committing genocide in the next 2 days? Definitely not. So a final decision in these kinds of cases can take years, if not decades to come to. The hearing over the next few days is to establish whether or not the court has jurisdiction and whether or not South Africa has presented a prima facie case that Israel has violated some part of the Genocide Convention. So as a part of this initial consideration, they will also put forward provisional measures. Provisional measures are the meat of the next 2 days. South Africa has asked for provisional measures to be enforced on Israel, and provisional measures are kind of like a restraining order. They're put in place so the situation doesn't get worse while the court deliberates the case in front of them. South Africa have asked for some provisional measures, and the court will decide whether or not to impose them over the next few days. In order to impose provisional measures, the court does not need to make a decision whether or not Israel is committing genocide. It can instruct Israel to do certain things, but suspend its final judgment on those matters. At this stage, the standard of evidence is very low. South Africa doesn't have to prove that Israel is committing genocide. It just has to demonstrate that Israel's operations in Gaza create a situation where there is a danger that the convention could be violated. This was clarified in the Gambia v. Myanmar, where the court stated that when considering provisional measures, it is not required to determine whether a violation of the Genocide Convention has actually been committed, but only to determine whether the circumstances require an order interim to protect the rights arising from the convention. Whatever decisions are made at this stage, they're not indicative of the ultimate decision down the road. If the case does go to the merits stage, that would take a really long time to get through. The provisional measures should hopefully be handed down within a few weeks or months at the very most. In the Myanmar case, measures were imposed within a month after the hearing. When the ICJ heard the preliminary case that Canada and the Netherlands put forward against Syria, that was in relation to torture, not genocide. It took over 5 months for measures to be handed down, but with Ukraine and Russia, it only took 2 weeks after the public hearing. So it should be within a couple of weeks, hopefully. Part of what they determine is how urgent the situation is. So today, the South Africa team will give an overview of the case, and then different parts of their legal party will get up to deal with specific parts of the complaint, and it's likely to be largely focused on the provisional measures. So each team has a top lawyer. So Malcolm Shaw is the top lawyer for Israel, and John Duggard is the top lawyer for South Africa, and it is my instinct that they will really focus on the provisional measures and why they should or should not be imposed. What provisional measures have been asked for? Obviously, when someone suggests that a state is breaching the Genocide Convention, that is seen as an urgent situation. Because of this, South Africa asked for an expedited hearing so that these provisional measures could be imposed. South Africa requests that Israel take all measures to prevent genocide. That's kind of the broad one. But knowing that that's super broad and that leaves a lot of wiggle room, South Africa's legal team have gone to great lengths to suggest more specific provisions. So in this case, South Africa has called for the immediate suspension of military operations in and against Gaza, that individuals under the State of Israel's control do not engage in direct or public incitement of genocide, and that they be held accountable as required in the convention. They've also been requested to take all measures within their power, including rescinding of relevant orders, to prevent the deprivation of access to adequate food and water. And they've been asked to submit reports on measures taken to abide by provisional measures ordered, and of course refrain from taking action which might aggravate or extend the dispute before the court. The biggest ask, obviously, is the suspension of military operations. It is my assumption that Israel will fight really hard against this provisional measure being implemented. It is a unilateral ask, so a provisional measure being enforced against Israel and not Hamas. That is, of course, because the ICJ has no jurisdiction when it comes to Hamas, so they can't really do anything. They could put it in writing that Hamas is also expected to cease military operations, but it's not enforceable in any real kind of way. They could also write that Israel has to suspend military operations until there is a further attack, which kind of implicitly suggests that Hamas should stop fighting. Of all of the provisional measures, I think this one is the most unlikely. South Africa's best angle to this is that it requires an immediate humanitarian ceasefire, because other humanitarian measures are necessary but not sufficient, in that we have a lot of information coming from the UN that it doesn't matter how much aid is coming in, so long as military operations continue, it will not be sufficient to deal with the humanitarian crisis. There will not be the ability for humanitarian access. There will not be the ability to keep up with the demand for aid. Something that I think will be discussed is whether or not such a provisional measure undermines Israel's right to self-defense. The United Nations General Assembly resolution also found that humanitarian ceasefires did not undermine Israel's right to self-defense. We could talk about whether or not Israel has a valid right to self-defense, but we'll do that later. But ultimately, I think this is South Africa's strongest argument for a suspension of hostilities, that they are required and the only possible way to stop further famine and spread of disease. Other measures that might be asked for would be fact-finding missions, allowing access to teams from the ICC or the United Nations, allowing access for journalists to ride along with humanitarian drops. Similar measures to this were implemented in Myanmar, but Israel, of course, will probably argue that that would have implications for their military strategy. I think the one that we'll see the most movement on is the suppression or punishment of genocidal statements by Israel. We've already seen some movement on that actually in the last couple of days. So I think we'll see a stronger requirement of Israel to take action on genocidal statements. But obviously the most likely provisional measure will be an order that has a requirement for access in relation to humanitarian aid. So this would be things like allowing in more medicine, allowing in more food, and of course turning on the water. Who are the judges? The ICJ has 15 judges who serve 9-year terms, and they're appointed by the United Nations. Now, judges come from all over the world, and they're expected to be impartial legal experts, not extensions of the point of view of their home country. Of course, that isn't always true, but that's the idea. Because the idea of representing people from across the entire world is to represent a range of different legal philosophies and legal traditions and perspectives. When a case is presented to the court and neither of the states that are party to the case have a judge on the bench, they can appoint an ad hoc judge, and that ad hoc judge will serve on the bench for that case. Neither South Africa or Israel currently have a judge on the bench, so they have both appointed an ad hoc judge. Ad hoc judges vary slightly more in terms of how independent they are. Obviously, anything they say is legally to a standard that it shouldn't really be questioned. And states want to pick a judge that everyone is going to respect in terms of their legal mind and their reputation. The ad hoc judges we have in this case, South Africa has selected Dikgang Moseneke and Israel has selected Aharon Barak. Both of these people are formidable in their field, great legal minds, but they also have something else in common, which I found really interesting. Barak survived the Shoah. He is a child of the Holocaust, and Moseneke was imprisoned at 15 for anti-apartheid activity. He's a child of the apartheid. While neither of them would use their personal history as a grounds for any legal opinion, their presence and their personal narratives do shape how we see things, especially when you consider how important minority decisions can end up being. These personal narratives, this history has political weight to it, and it's also interesting because in a way these judges both represent the collective suffering of their communities. What are the key points in South Africa's petition? South Africa is claiming that Israel's military operations in Gaza constitute genocidal acts and violate the convention. It asserts that Israel has killed in excess of 21,110 named Palestinians, including over 7,729 children, with over 7,780 others missing, presumed dead under the rubble, and has injured over 55,243 other Palestinians. And that Israel has also laid waste to vast areas of Gaza, including entire neighborhoods, and has damaged or destroyed in excess of 355,000 Palestinian homes. It is important to note that the application does appropriately acknowledge and condemn the actions of Hamas on October 7, but it is also unequivocal that no armed attack on a state's territory, no matter how serious, even an attack involving atrocity crimes, can provide any possible justification for or defense to breaches of the Genocide Convention. There are a few things that are notable about this application. First is that it really considers context. The application acknowledges the broader context of Israel's conduct towards Palestinians during its 75-year-long apartheid, its 56-year-long belligerent occupation of Palestinian territory, and its 16-year-long blockade. This is really seen within the context of apartheid. So that is interesting and not something that is necessarily in other similar cases, especially because there is a desire to legally abstract the current event. South Africa have completely avoided that abstraction, said no, we can't understand these events without that historical context. In order to demonstrate genocidal intent, South Africa claims that Israel's failure to provide or ensure essential food, water, medicine, fuel, shelter, and other humanitarian assistance for the besieged and blockaded Palestinian people, and its sustained bombardment has forced the evacuation of 1.9 million people, or 85% of the population of Gaza, from their homes and herded them into an even smaller area without adequate shelter, in which they continue to be attacked, killed, and harmed. The other thing that is unique about this application is incitement. The genocidal rhetoric of key figures in Israel is used in two ways in South Africa's petition. It demonstrates a violation of the prohibition of genocidal incitement, which is in itself prohibited in the convention, but it also uses statements as evidence for intent. In other cases, like in the Myanmar case, we have reports from UN bodies which can be used as substantive evidence to demonstrate genocidal acts, but obviously no one can get into Gaza. So there's very little evidence in that kind of way that is available. So in its place, South Africa have extensively documented genocidal rhetoric from key members of Israel's political and military elite. So they have included more than 60 quotes that they believe demonstrate an intent to destroy, especially when paired with what is visible on the news. Israel, of course, will suggest that there is no relationship between the rhetoric and the military operations on the ground. That, of course, is hard to prove when these genocidal statements are coming from heads of state, members of the Knesset, leaders of the military. It's even harder to prove when no steps have been taken to condemn these statements or to hold people accountable using law enforcement. Although it is important to note that yesterday Israel did issue a statement reminding everyone that genocidal rhetoric or incitement is a crime in Israel. So I don't know if that's in relation to this case, but it's interesting. The final thing that I think is really interesting in South Africa's petition is the focus on children. It of course goes without saying that children have been overwhelmingly affected by operations in Gaza. The number of children killed in Gaza since October 7 is now higher than the entire death toll of the siege of Sarajevo, and that took 4 years, whereas this has only been a matter of months. But another strategic reason that I think children were included was the additional interpretations submitted to the court in relation to children when it came to the Myanmar case. So here's some of what was said. There is a lower threshold for serious bodily or mental harm when the victim is a child. Acts which may not be regarded as contributing to the physical or biological destruction of the group when done to adults might be regarded as meeting those thresholds when done to children. It is important to adopt a construction which recognizes that what it means for a child to suffer grave and long-term disadvantage to their ability to lead a normal and constructive life may be different from that of an adult. The targeting of children may assist in demonstrating that the members of the group were targeted because of their membership of the protected group. Evidence that children have been targeted on a significant scale would be likely to preclude a defense that members of the protected group were targeted solely for certain other reasons, such as that they pose a security threat. Where children are targeted through underlying acts of genocide, this may assist in demonstrating the existence of the requisite intent. Given the significance of children to the survival of all groups, evidence of harm to children may contribute to an inference that the perpetrators intended to destroy a substantial part of the protected group. What is Israel likely to say in response? Well, firstly, it's obviously very clear that Israel is going to deny that it is in violation of the convention. It will deny that any of its acts are genocidal. Keep in mind, we're not at the merit stage of the case. So Israel will be largely focusing their presentation on provisional measures. I think it's likely that Israel will argue that all of its military actions are justified by Article 51, whether or not that applies here, and they're going to use that to both refute the claims of genocide, and they're going to use that to try and limit provisional measures which impose restrictions on their military operations. Now, of course, I want to be clear that self-defense, even if extremely legitimate, is not a justification for genocide. They might claim that because of self-defense, that might create some jurisdictional issues, but the ICJ has made a lot of decisions where self-defense is a pertinent factor. Even when it comes to Israel, they made a decision about the legality of Israel's wall, which Israel claimed was for self-defense, and the ICJ found self-defense did not apply. The court has imposed provisional measures that limit use of force even in situations where self-defense has been invoked. So in the Congo and Uganda in 2000, not to mention Russia and the request to suspend all military operations, even though Russia was claiming self-defense, and of course in Nicaragua in the 1980s. In fact, the ICJ stated there, as to the inherent right of self-defense, the fact that it is referred to in the Charter as a right is indicative of a legal dimension. If in the present proceedings it becomes necessary for the court to judge in this respect between the parties, for the rights of no other state may be adjudicated in these proceedings, it cannot be debarred from doing so by the existence of a procedure for the states concerned to report the Security Council in this connection. So the big thing that Israel might try and say is that because there's self-defense and because there's use of force, this isn't for the ICJ to decide, this needs to be dealt with by the Security Council. But they already decided that wasn't the case in the Nicaragua case in the 80s. They basically said that they have the right to make judgments on self-defense. Yeah, they made that decision. There might also be claims that the court is playing politics, or is the court playing politics? It is possible that pressure will be put on the court suggesting that it's interfering in a highly political situation, but the ICJ is pretty steadfast in its position that it can decide a case even when there are strong political aspects. In fact, the last decision the court made on an issue concerning Israel and Palestine, the court stated, whatever its political aspects, the court cannot refuse to admit the legal character of a question which invites it to discharge an essential judicial task. Since its existence, the court has never refused to adjudicate a case on political grounds, or because a conflict involves a serious use of force and they believe it should be dealt with by the Security Council. So hopefully that's given you an overview of everything you need. The 84-page document, I didn't want to go through the complaint and summarize the complaint. You should just read it. The South Africa team have done such an outstanding job, but hopefully I've given you enough information here to at least assist in following the case over the next few days.